Misa proposed that the Senate give immediately emergency powers to the Supreme Chancellor.
It is with great reluctance that I have agreed to this calling. I love democracy. I love the Republic. The power you give me, I will lay down when this crisis has abated.
The time was 3:30 a.m. The House of Representatives adopts the Senate's final version of the Bayanihan Act, which gives a wide array of emergency powers to the President. Senate Bill 1418 is now to be presented to the President for signing.
Welcome to Debatable. In this episode, we're going to discuss Senate Bill 1418.
Just a disclaimer for this episode, I am not a lawyer. This is my opinion and a personal reading of the bill. Nothing I say here should be understood as definitive or authoritative. You should not be treating this as legal advice because that's illegal for me to do.
Also, another disclaimer, I am not also a lawyer. I am a mere pol-sci graduate. And I agree with Kyle. There's also so much unfolding regarding this issue, so make sure you read up from other sources. Also, Kyle is the one who objectively understands this issue more, given he knows all the legal jargon. So I'll just be chiming in once in a while to ask questions, and probably give my opinions on political matters.
Alright, so we have this bill that confers emergency powers to the President. And the basis of that is the Constitution. The Constitution actually allows the Congress to do this in Article 6, Section 23, Paragraph 2, which reads, and I'm going to read this verbatim, "In times of war or other national emergency, the Congress may, by law, authorize the President for a limited period and subject to restrictions as it may prescribe, to exercise powers necessary and proper to carry out the declared national policy. And unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof." So that's what the Constitution says. So when we're talking about emergency powers that are given by the Congress, that does not necessarily mean that it's martial law. So even if it might look like it's martial law, it's technically not martial law.
So obviously this was a bill made in light of the coronavirus, which is seen as sort of the national emergency. But how did they make it such that it legitimized even needing emergency power and not martial law?
Well, okay, the main difference between martial law and emergency powers is that emergency powers emanate from Congress. So it's delegated to the President. So the President cannot go beyond the powers that he's been delegated. But with martial law, what would need to happen is that there first needs to be an actual rebellion or invasion, and in this case you can't see a rebellion, you can't see an invasion, right? So at this point it's impossible for the President to use this medical public health emergency as a basis for martial law. But in order to legitimize it, even in the explanatory note, it said that the main basis, in fact, for why there should be emergency powers is just like the spread of the virus and the fact that we have a public health emergency.
That's fair. I think, though, if you could try, probably some people could claim that this is something that merits martial law, especially since people have been disobeying. I'd say people have been seeing that as a sort of rebellion, but there's no invasion. Unless you count like the invasion of the virus into your immune system.
Yeah, I think
but that is ridiculous.
I think for invasion, we have to take a look at the existence of other countries, for example, like wars, for instance. And if there's a war, and that's what you mean by invasion, there first needs to be a pronouncement coming from Congress that there is in fact a war. But since there is no such pronouncement by Congress, then you can't consider this to be an invasion. And I also don't think that you can consider this to be a rebellion, even though people are disobeying laws, for example, or the government or whatever quarantine there is. That's not rebellion, because technically if you're looking at rebellion, you have to look at the revised penal code. And the revised penal code is very strict in saying that when you're talking about rebellion, the goal has to be to depose the government or to remove from sovereignty some territories within the Philippines, either in whole or in part. So it's obviously not a rebellion. It's also not an invasion. So I think we can rest a little bit assured that the president will not be able to exercise martial law.
Alright, so at least we're now pretty clear that it's not martial law, despite people's fears of it. But this bill, like you mentioned to me in person, is pretty problematic still. So let's kind of dissect that and talk about why, probably.
Yeah, so the first thing I want to take a look at is the effectivity of the emergency powers. Like, how long will the emergency powers last? Because what the bill says is that it is effective immediately upon publication in a newspaper of general circulation or the official gazette for 3 months unless extended by Congress, provided that the powers granted under this act may be withdrawn sooner by means of resolution by Congress or ended by presidential proclamation. So, just a little bit of legislative background here. The original bill said that it would be effective 2 months, which may be extended by the president himself. So the president, under the original bill, would have to first determine that the calamity still persists after the initial 2 months, and he could extend it unilaterally. And what the Congress can do is to withdraw that power from the president, or he can still end it by presidential proclamation. So the problem with the original version was that the president had too much unilateral power over whether he retains his power. He had the ability to extend the effectivity of his powers, and we just have to trust that his assessment of whether or not there's a calamity is correct. And in the worst case, if he extends it, we cannot challenge the factual basis. So for example, in the original version, if that were the bill that was supposed to be signed by the president, what could happen is that the president, after the first 2 months, says, "Oh, may calamity pa rin, I'm going to extend it," even though, and then if people on the ground say, "Oh, there's no calamity anymore, people are chill, let's challenge this exercise of emergency power," probably the Supreme Court will go like, "Nah, no, you can't do that," because there were cases before, the Mindanao martial law cases, where the petitioner was challenging the imposition of martial law in Mindanao by saying there's no factual basis to support this. There isn't really a rebellion. There's no invasion here either. And then the court said, probably there is. It's just that it's confidential information known only by the president. So if the original wording of the bill was the one that's retained here, it's very difficult to challenge, even if the facts don't reflect his pronouncements. And another problem is, if you look at the Constitution, and I said this earlier, the Constitution says that the emergency powers will stop in only one of 3 ways. The first one is the end of the limited period. The second is that it's withdrawn by Congress. And third, if it's not withdrawn earlier by Congress, then it would be automatic upon the adjournment of Congress. And this list in the Constitution seems to be exclusive. Like, you can't add to it. It's exclusive, right? So, and you see in the case of the constitutional provision, the words like shall, and that means like you have to do it. Like, there's no other way for you to do it. Because other constitutional provisions, they use the word may. And if you use the word may, that means you can do it this way, or you can also do it some other way, which is how the court decided on the quo warranto case against Sereno, if you remember, where people were saying that, quo warranto is not the proper way to impeach this officer, through impeachment lang. And then the Supreme Court said, no, read the provision. It says may be impeached, so not exclusively impeached. But here, the use of the word shall means that you can't add to it. But in the old bill, as well as in this bill, the problem still exists that you allow the president the option to choose the length of the effectivity up to the 3 months. But I would still say that the old bill is more dangerous. Like, for example, because the president had the ability to unilaterally extend the period under the old bill, it frustrates the Constitution's mandate that the grant of emergency powers was for limited time only. And the reason why I think it's supposed to be exclusive is because the president shouldn't be allowed to make any decision here. Like his emergency powers are delegated by the Congress, right? So all of the ways that he can exercise or not exercise that power also has to be delegated. It's given by the people through the Congress, and he should literally have no choice but to exercise it for as long as the Congress determines that he should be.
It's kind of just upsetting that in a normal world, the language of the bill shouldn't be a problem, because we should be trusting that the spirit of the law should be followed. But given our experiences, especially with the impeachment, for example, we can see how people are so willing to twist words just to get the outcome that they want. Do you really think, though, that with the old wording, they would have probably abused it in any way?
Well, I'm not sure, like, if it was actually going to happen, but what I can say is that it is more likely that it could happen. So I think my attitude when I look at the law is I try to think of all the different ways that it could be abused, and I don't think that I should trust anyone with any power unless I am sure that the law specifically limits any kind of abuse like that.
Isn't that like a principle in reading law or something?
Yeah, it's from Justice Holmes, actually. He said in The Path of Law, if I'm not mistaken, that's the name of the article that he wrote. In The Path of Law, he calls this the bad man theory, where if you read or write laws, you always have to think like you are the bad man, and you want to break the law or try to skirt the law or do some bad stuff. But in cases where you give more power to the government, the bad man or the bad person that you want to take the shoes of isn't like the criminals who are the quote-unquote criminals who are violating quarantine, but the people who are actually supposed to exercise the power, which is the government itself.
How many revisions did
How
many revisions did this law go through? We keep talking about the old one and the new one, but we're not really that clear yet.
Quite a few, actually. But what I'm looking at is the original bill that was sent to the Senate compared to Senate Bill 1418, which is the recent one that was adopted by both the Senate and the House this morning. Really, really early. I'm not even sure if you could consider that morning. Maybe that's nighttime because it's 3:30 a.m.
But why did they rush it though?
Well, pag emergency kasi, and it's very urgent, you can rush it. So, right, you have 3 readings. Usually kasi if it's just any other normal law, you would take 3 days. Like, you distribute copies to them, give 3 days. But if it's urgent, certified urgent by the president, they can waive that. So, like the Constitution says that if it is certified urgent, you can waive some things. But just to be clear, you still have to do the readings. You still have to do multiple readings. The only thing that you're waiving is the 3-day period by which, like, the houses of Congress are supposed to read up on the bill some more. Then immediate na, like, let's go deliberate on this na.
Yeah, it feels like it's counterintuitive though. It feels kind of counterintuitive. Isn't the reason you need 3 readings, or at least like in my discussion in Paul's side, the reason you need 3 readings is to really dissect the law and then properly understand it, scrutinize it. But if you rush it and the president's allowed to rush it, it kind of defeats the purpose of having 3 readings. Chances are they're not even reading it that well.
Yeah, but then again, even in the instance in which they were given 3 days, it's not really an assurance that people read it either. Yeah, and yeah, I suppose, like, it's supposed to be corrected during the deliberations itself. But then we have heard that a lot of people were prevented from participating in those deliberations earlier. And people were saying, oh, it's unfair.
Yeah, wasn't there like supposed to be an interpellation that they just canceled because they wanted to rush it?
Yeah. So anyway, Since we talked about the bad man theory already, let's take a look at the authorized powers that we gave to the president. The first one, in paragraph 1, this is section 4, paragraph 1, says that the president has the power to, quote-unquote, suppress the transmission of COVID-19 through education, detection, protection, and treatment. Okay, so the original version of the bill didn't say through education, detection, protection, and treatment. So it was like a general statement that you're supposed to suppress and minimize transmission and the spread of the disease. So it was super vague. So the problem with that is that it could mean something else entirely, like something that's not about education, not about detection, protection, or treatment, like a supercalifragilisticexpialidocious quarantine with extreme enhancement or something. But the problem with the amended version is that it's still unnecessary. Like, he already has the power as the president to do all these things, like the power to facilitate education, treatment, because like, sino ba yung gagawa nito? It's the DOH, it's the DepEd if we're talking about education or something. But the secretaries of those departments are literally alter egos of the president. So this is just a restatement of a power that he already has.
Yeah. And even if he edited it and it was edited already, education, detection, protection, treatment, they still sound super vague. What does that look like? Did it specify it in any way?
No, they didn't specify it in any way, which is why it's kind of bad. But another power that was given to the president is to expedite the accreditation of testing kits and prompt testing by public and designated private institutions and immediate treatment of patients. In the original, it only talked about testing, but in the new one, it also talked about accreditation of kits, which is good because in order to make testing a thing, you need to be able to have more kits, like cheaper kits, more effective kits, etc. But since we're talking about good things as well, I want to take a look at paragraph 5, for example, which says continue to enforce measures to protect people from hoarding and profiteering. Paragraph 6 says donations should not be delayed. Paragraph 7 says procurement of goods and services should be expedited as an exemption from the Government Procurement Reform Act, because the Government Procurement Reform Act is notoriously slow. Like, I have friends in government who have to work with procurement, and it is literally the worst thing ever daw, sabi. Paragraph 8 of section 4 says that they can partner with Red Cross. Another paragraph says create incentives for manufacturing and requiring business to accept contracts for provision of those goods, etc. And so a lot of the things that are mentioned in the bill are actually good. Majority of them, though, are already within the president's power to do. I mean, if we're talking about, for example, accreditation of kits, like, who does that? The accreditation of kits usually is done by the FDA, and the FDA is an administrative agency under the control of the executive branch, which means that the president already had the power to do this. And when you take a look at things like continue to enforce measures to protect people from hoarding and profiteering, like, you're not making any new law, you're just enforcing the laws that are already existing. So do you mean to tell me that the president could not enforce a simple law before this, the law that already existed against hoarding and profiteering, without the grant of emergency powers? Because, like, in the original, right, it says that the president can, quote-unquote, adopt or make his own measures against hoarding. But now it's changed to enforce. Since it's just about enforcing already existing law, girl, that's literally what a president is supposed to do. That's his fucking job description. And hoarding and profiteering has special definitions in the Price Act. So there's already a law that you're supposed to enforce. You're not supposed to give an extra power for this. And hoarding by individuals can be solved by LGUs. Like, look at the examples of Pasig and Valenzuela.
Yeah, so this seems to be just a really mema part of the bill. I'm not even sure how it's going to be different. Like, what does having special powers do that make it so much easier to stop these bad things from happening that the presidential powers can't already achieve?
I would say that at best it is just mema, but at worst, because it is vague in this particular way, like, we omitted the use of the word adopt. We just used enforced. But you could reasonably say that there might be a reasonable reading that says that he can make his own measures, right? So I think at worst, the vagueness that this creates makes the president able to make his own law.
Let's hope it doesn't get to that.
Yeah, and since I was just talking about Pasig and Valenzuela, the next paragraph 3, says that the president should ensure that all LGUs are acting in line with the regulations of the national government and are implementing it exactly. Like, local government units are not allowed to go beyond or below the prescriptions made by the national government, unless it is a matter undefined by the national government. So I think here we're talking about like Vico Soto or something, and it's kind of obvious that it is about mayors like Vico Soto. But I think a problem here is that LGUs go beyond the prescription of the national government or fall short specifically because the regulations are so unclear to begin with. So in this case, LGUs are trapped now to follow counterintuitive measures, or they're trapped in a situation where they don't know the bounds of what is acceptable or not because the national government was so unclear.
Yeah, so this is literally removing the check and balance of the LGUs and towards the national government. And personally, to me, it didn't make sense because not only was it very restrictive to LGUs who probably know their constituents best, but it's very different from the stance Duterte took before. He was very pro-federalism, very pro-LGU. He wanted people to do things in manners that he felt were most appropriate for their constituents. But suddenly, when he's in power, he's no longer for this advocacy. So I've ranted about this a lot, but I think besides the legal issues, it's also very against the purposes of having these divisions of power in the first place.
Okay, so next let's talk about takeover, which is the next paragraph of the powers that are given to the president. So just a legal background for this power. Article 12, Section 17 of the Constitution says that at times of national emergency and when the public interest so requires, the state may, during the emergency and under reasonable terms, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. And let's take a look at the legislative background here. Originally, the Senate bill says that the president is allowed to take over any public utility or business affected by public interest. So, copy-paste lang nila from the Constitution, including, for some reason, telecommunications, which is way too vague because, like, any public utility can be taken over by the government even if they're not reasonably related to COVID-19. So, they tried to fix that in Senate Bill 1418, making it more limited. So now the questions that we have to ask are, who can be taken over and for what? So the who here, under Senate Bill 1418, is any privately owned hospitals and medical health facilities, including passenger vessels and other establishments to house health workers. So the reason why they want to do that is to house the frontliners, to create aid and relief distribution centers to transport frontliners, etc. So my comment here is, I mean, okay, that's fine. And the reason why I think it's okay is because in practice, I think a lot of private hospitals, for example, are refusing to admit COVID patients. So to that extent, I think it's better than before. Although some people would argue that why are we trying to limit private establishments? Like, they're not doing anything wrong. They're working pretty fine.
Well, I would say not really. There was a really big issue released on Twitter where St. Luke's Medical Center didn't want to accept any COVID patients despite bragging that they are like the top facility in the country, etc. So I think this original bill or the original intention was to target those kinds of establishments.
Yeah, I get that. But I would say that by and large, they're not as bad as like the government makes it look like they are. But I do accept that there are some. But anyway, I think Okay, I have a few issues with this. The first one is that I'm a bit apprehensive about the wording in the law that says hospitals, passenger vessels, other establishments, because by using the words other establishments, it means that it's not an exclusive list. You can add more things to it. But we have to construe other establishments in light of the other specific establishments that they're supposed to be similar to. So there's this rule in statutory construction, or basically reading the law. Statutory construction is a fancy schmancy legalese word, a phrase for reading the law. So one of the ways that we can read a law is using this legal maxim called ejus dem generis. Basically what that says is that if there's a specific list like X, Y, Z, and after that specific list there is a general word saying and others, for example, others has to be read in conjunction with X, Y, and Z. So you have to find what is common between that. So what is common between hospitals, passenger vessels, and medical health facilities? To me, it means the ability to carry people, the ability to transport, and I don't know, maybe the ability to take care of people. But that's just to me. Other people might be able to say that what's common between them, that's just me. Other people might be able to say that actually what's common here is just the ability to hold a lot of people. So siguro you can take over some other things that are not within that list and it will be perfectly fine depending on how you read this. Also, public utilities or franchises could have their franchises amended by Congress to reflect this to begin with without giving the president these powers. Because the same article of the Constitution, Article 12, says that no franchise shall be granted except under the condition that it be subject to amendment by Congress when the common good so requires. And also, if hospitals, the government can actually enter into lease agreements, or if they're uncooperative, even local government units can use eminent domain to take over the land without having to give powers to the president.
So what is the added benefit of including this then in the bill?
The added benefit here is that there are lots of procedural requirements that you can just go past. So for example, if you enter into a lease agreement, for example, and like some local government units have actually done this, they still needed to make negotiations for creating the lease agreements. If it's about eminent domain, there has to be expropriation proceedings. You need to draft an entirely new ordinance, for example, to take control of that land, possess it, give just compensation, whatever. So there are lots of procedures that are bypassed as a result of taking over the business. And well, to be fair, the Senate bill says that the owners or the managers still get to run the operations, and they are entitled to damages. But the point is the bill doesn't say how they're gonna do it. It just says that the president has the power to do it. So it is the president who will decide what the procedure to be followed will be.
So it's really just efficiency.
So a lot of procedures may be bypassed.
Yeah, so it's just efficiency.
Yeah, it's literally just efficiency. Yeah. Another thing that is actually pretty important is compensation of workers, because paragraph 9 empowers the president to engage temporary human resources for health and for human resources for health to supplement the workforce, and they should be given compensation and hazard pay. Because what happens is what's happening right now is like you already have a workforce, but it's not enough. So you're calling for volunteers, but as it stands right now, you're not required to pay the volunteers anything, even if they're temporary human resources for health, because there's no law that says you should give them money. But under this paragraph, they should be given appropriate compensation and hazard pay. So I'm like, dude, like finally, like we should stop this whole volunteer for no pay thing. And this is one of the things not covered under any present law.
Okay.
So I think this might be good. Kaso, my problem is, why does it have to be a president's emergency power to be able to do this? So non-volunteers had hazard pay already. Now temporary human resources for health, as well as the current health workforce, now have compensation and allowance. So the new computation is, you have hazard pay, which is 25%, and an additional special risk allowance, because according to Grace Poe, COVID-19 is a special kind of hazard, so you need to have a special kind of hazard pay, and they call this a special risk allowance. But we don't know yet how that allowance will be computed.
Again, though, I don't understand why the emergency power is needed. I guess it's just another efficiency issue.
Yeah, but I think that, like, if they had the time to go through this many readings to read to read a bill that will give the president these powers, they could have easily took the same amount of time to read a bill that will give the same benefits to workers. Yeah, so anyway, since we're talking about money, let's now go on to budget. And this is something that I'm dreading. I've been dreading this entire recording session from talking about, because it's the budget and no one wants to talk about the budget. But okay, just a summary. Under the Senate Bill 1418, paragraph 17 allows the president to discontinue or direct the discontinuance of the programs of the executive department and to use the money that was saved to augment support operations. Paragraph 18, on the other hand, says that the unutilized balance or savings in special purpose funds will be used to augment those same operations. And the last one, paragraph 19, this is the most controversial, allows the president to realign funds that were allocated from the savings of other items in the executive department into other things. So augmentation pa rin siya. There are a few problems here. The first one is that you could argue that it's unnecessary to have paragraphs 17 and 18. The first two, like discontinuing programs, unutilized balance, it's unnecessary to make it a part of emergency powers, because the canceling of projects, he can already do that kasi sa kanya yun basta authorized by Congress, and unused funds are allowed to be appropriated to his office. And that's already in the Constitution. The original version of the third one about realigning and reappropriating was unconstitutional because it allowed the president to reallocate funding from anywhere, even for projects beyond his office. So the Constitution, the relevant portion of the Constitution, says that this is section 25 of Article 6, says that no law shall be passed authorizing any transfer of appropriations. However, the president may, by law, be authorized to augment any item in the General Appropriations Law for his respective office from savings and other items of his respective appropriations. So it's a very complicated thing to talk about, but it's easier if you think about it in terms of what is allowed, what is not allowed. So what is allowed is that the president can augment the funding for his projects using savings from his other projects. So if the GAA, the General Appropriations Law, says that the president's project A has an allocation of 10 million and his project B is 20 million, and the president only used 10 million for project B, the unused money that is allocated to project B can be used to augment the funding for project A. What is not allowed is transferring money that wasn't even allocated to the president at all. So, no law shall be passed authorizing the transfer of appropriations. That just means that if there is budget that is not allocated to your office as the president, you can't get money from other places in the government that wasn't allocated to you. So the reason for this is because, okay, so you might ask, why is it that pwedeng i-reallocate if it's savings, but it's bawal if it's from others? The reason for this is to find a balance between what is given to the president and also flexibility. So Congress cannot anticipate all the issues and needs that may come into play once the budget reaches its execution stage. It is not practicable for the Congress to adjust and pass a new appropriation bill after each and every development, which is why the president should be able to reallocate funds as needs arise. So there was talk a few years ago about PDAF, where there was some discretionary funds and it was challenged, and the court said that having discretionary power over the budget is not per se a bad thing, as long as it was already allocated to your office in general, and the Congress allows you to use some funding and unused funds or savings and reallocate them into your other projects. So historically, this practice was around since 1909. But there are obviously limits that are imposed by the Constitution. Like, you can't touch what isn't yours. The president can't touch money that was never allocated to his office. He cannot use all the country's money, only the money that his office was entitled to from the very beginning.
Yeah, so again, I feel like this part of the bill seems unnecessary. It's just kind of reiterating what's already allowed. My speculation was they wanted the original version, which was to allow the president to just get funds from others and reallocate anywhere. And then they realized they couldn't do that, so they took it out. But they just didn't take out this entire section altogether. But why not though?
Yeah, so what I would say is you're definitely correct that it doesn't need to be labeled as an emergency power if it's something that could have been allowed. But remember that the Constitution says that the president can only augment items from unused money from other items of his appropriation if there's a law that is authorizing him to do that. So I suppose that he has a lot of unused funds from his other projects, and he wants to use that unused funds, put them into his anti-COVID operations. But he can't do that unless there is an authorization coming from Congress. So I agree that this part of the bill should happen. It's just that I don't agree that it should be considered an emergency power.
Is there like a big harm if it is though? So I'm guessing that this emergency power, or they just put it in this bill, sort of like to hit hit two birds with one stone, because it's easier to just include this compared to doing a separate bill to achieve the same purpose.
Yeah, I guess so. But for me, kasi the problem here is that there are so many things that you don't really need emergency powers for. So a lot of it looks reasonable, but there are some parts that might look unreasonable if that was the only focus of the bill. So because you lump it together with a lot of reasonable provisions, you go like, okay, yeah, let's pass it. But a lot of the things that are really vague, like they slip under our radars, and that's for me the danger here. Which leads us to the next part, the others. That's what I call it, because the last power that is given to the president is the power to carry out such other measures as may be reasonable and necessary to enable the president to carry out the declared national policy subject to the Bill of Rights and other constitutional guarantees. So my first reaction when I read this was, what does that mean? What does it mean to have such other measures that may be reasonable and necessary to enable the president to carry out the declared national policy? It's really vague. But thankfully it says to carry out the declared national policy. So it would be helpful to note that even in this bill, as with most other bills, there is a section called the Declaration of Policy, and this section usually provides the guiding principles behind the law. So there's a section here, if I'm not mistaken, it was section 3, that gives the Declaration of Policy. And the Declaration of Policy gives an enumeration of the goals that we're trying to achieve. So the first one is to minimize the transmission of COVID-19. The second one is to mobilize assistance. The third one is to provide healthcare, I think. Another one is to prevent the overburdening of the healthcare system. The other one is to recover and rehabilitate people and give them welfare. and let's also ensure the funds to do those things. But the last goal in the declaration of policy is to protect the collective interests at this most challenging time, or something like that. So that last one is really, really vague. Even the declaration of policy is vague, because the first 6, they're reasonable and related to COVID-19, but the 7th could mean anything, even if it's not related to COVID-19. So in relation to the power that we gave to the president, such other measures as may be reasonable and necessary to enable the president to carry out the declared national policy could mean anything, even if it's not necessarily related to the prevention of the spread of the disease.
Like what?
For example, you could argue that there must be a reason why at this point in time, right, there seems to be an influx of a lot of news about the NPA again, right, about domestic terrorism.
Yeah.
So those other quote-unquote national security concerns that are not necessarily related to COVID, measures that the president can take in order to stem out dissent, for example, those could reasonably be part of the such other measures that are reasonable and necessary to enable the president to protect our collective interests. And yung sinasabi na subject to the Bill of Rights and other constitutional guarantees, a lot of our constitutional guarantees can be limited by law. So for example, our freedom to information, there needs to be a law that allows you to get that information. If there is, for example, freedom of speech, it can be limited by law by saying that there is a clear and present danger that will arise from you making that speech, which is why there are lots of libel laws, for instance, defamation laws, and incitement to sedition or rebellion. So free speech can be limited if there is a law and the law is reasonable. So there are lots of things that the president can now be able to do specifically because this catch-all provision is so vague. It refers to a declared national policy that is in the bill, which is in turn also very vague and not necessarily always related to COVID-19. So we move on to penalties. It says that violations of the provisions of this act shall be punishable with imprisonment of 2 months or a fine ranging from 10,000 pesos to 1 million pesos. And I think that's very interesting because in the old bill, it says that we're imposing penalties on any violation of the rules issued pursuant hereto. But here, it's in the new one, it's violation of this act. So, how do you violate this act, right? How do you violate Senate Bill 1418? There is nothing here that says XYZ is prohibited. And, kasi this entire bill only says, here are the powers that we give to the president. So, literally, the penalties, stop mattering because the only way that penalties will be imposed if it is a violation of the rules that are issued. But since in this new version, the only way that you get the 2-month penalty is if you violate powers that are given to the president, which makes no sense, right?
Maybe it means if you refuse to acknowledge or grant the power to the president. I don't know.
Wala eh. It is the Congress that gave him that power. So the only way that this makes sense for me is if we're going to be punishing the president for not following the guidelines that are put in the bill. The problem with that is, the problem with the penalties provision is that it violates provisions of Senate Bill 1418. But the provisions of Senate Bill 1418 doesn't affect anybody except the president. So only the president could reasonably violate the bill. But the president cannot be sued while he's in office.
I don't know then. It's just MEMA.
So this is MEMA now. This is MEMA. But if you look at it the other way, I think this is the easier way. I think it's easier for me to want a provision that doesn't make any sense because it doesn't change anything, as opposed to it changes something but it's pretty bad. Because my original speculation with the old penalty, with the old provision, any violation of the rules issued pursuant thereto, it means that if the president says, okay, there is now a quarantine, and people violate that quarantine, those people can be punished with an imprisonment of 2 months or a fine of 10,000 to 1 million because they violated rules that are issued pursuant to the powers that were granted by the president to the president by this bill. So, kasi, I just want to stress that if you violate the quarantine and there's no ordinance that says violating quarantine comes with a penalty, there is no law that prohibits breaking quarantine. There is no law. People will say that, oh, look at RA 11332, which prohibits people from not cooperating. But those laws, those provisions in RA 11332 don't apply unless you are a frontliner or medical health worker, or you are a person who was actually diagnosed with COVID-19. So even under the present law, there is nothing that says that you're not allowed to refuse to cooperate with the quarantine. But under the old version of Senate of this bill, you could possibly be imprisoned for that na. But under this new version, that doesn't apply anymore. Okay, so last thing I want to talk about is construction. Because if I'm mistaken, Section 7 says that nothing in this bill shall be construed as an impairment, restriction, or modification in the Constitution. In case exercise of the powers herein granted conflicts with other statutes, orders, rules, or regulations, this act shall prevail. So the old version was unclear because it said that if the exercise of the powers granted in the bill conflict with other laws, then the act shall prevail. So there was some confusion, and some thought that this meant that the Constitution was superseded by the bill. And I think that's fair because I suppose people were thinking that the Constitution is also a law. So if the exercise of the powers granted by the bill conflict with the Constitution, then the powers given to the president prevail. But that's technically speaking not the correct way to go about it, because we do not really treat the Constitution as a law. Technically speaking, no law goes beyond the Constitution. It's not just a mere law. It is a law, but it is not. Do you see the problem here? It is a law, but it's not the kind of law that is referred to.
Yeah, this is the first thing we study in Pol Sci. So, the Constitution isn't just seen as a law in our perspective, or at least in the realm of Pol Sci. We see it as a structure. We see it as an institution in itself. So, it's the most important institution because it gives rise to other institutions, right? So, even if it is the law, it is sort of the genesis of all laws. So, we cannot have anything that overtakes it.
Yeah, exactly. So, no law, and this is useful for other future laws, siguro, when you read it, it's impossible for any law to be able to justify non-compliance with the Constitution because it creates a contradiction. The power of the law that you're reading emanates from the Constitution because it's the Constitution that empowered the legislature to make laws. So if the legislature is trying to contradict the Constitution, it is also contradicting its own source of power.
Yeah. You can't defeat God if you were created by God, sort of.
Yeah, you can't do that. Because if you contradict God and God is the reason for your existence, then existence ceases to exist.
Yeah, that's a...
This is the plot of a movie.
This is some philosophical thing already.
Yeah, it's dogma, diba? So anyway, I think that's it. This is a pretty lengthy one. it was very interesting recording about an event that literally happened only a few hours ago, less than 12 hours ago.
You had to do a lot of editing. Editing of your script, I mean.
Yeah.
What's the takeaway though? So I think we're just inciting fear in people. We're not talking about this to make you scared. Just aware. So obviously we are in unprecedented times. We don't know what's taking place. We don't know how things are going to happen moving forward. Like literally no president has had to deal with a pandemic of this scale. At least like when you talk about wars, we kind of know already what happened. We know what patterns to follow, what are good tactics to deal with it. And I think at this point, every country is just trying to deal with COVID-19 in their own way. And I don't know why, but the Philippines chose to grant emergency powers as a way of dealing with it. And I don't think any other country has granted emergency powers to their president. But it's just good to stay aware, especially since there are a lot of violations that are taking place on the ground. It's basically turning into a little bit of the purge with policemen doing whatever, like putting people in cages and etc. And we are basically just pointing out that what the government is doing is problematic. It can continue to be problematic. And even if we cannot change things, the least we can do is be vigilant so that the next time things escalate, we can find out why. And that this is the bill that probably will allow more problems to happen in the future.
Because also if you notice, I did a lot of discussion about why this didn't need to be an emergency power, because this was already something that can be done with existing mechanisms. So I think taking that into consideration, there isn't so much that this bill changes. I mean, there is a lot that will be changed, but we need to temper our fears with information. So what really is there to be afraid of? And that was the goal. That was our goal going into this episode. Na what are the things that we need to know? Because like people fear what we don't know, right? So if we know things, more things, it gives us more ammunition, metaphorical ammunition, I must clarify, to help us combat the fears that we currently have.
I like how you had to specify, like, it's metaphorical ammunition, you know? Like, we might be targeted by the PNP for this. So, in summary, it's not martial law. Like, best case, it's just a memo bill with some weird, repetitive provisions that already exist in other laws. Or worst case, it is vague enough that it can be abused. We're not saying it will be abused, but it can be abused, so it will be good to keep in mind what these loopholes were in case anything happens in the future. So that's it for this episode. Thanks for listening. We'll see you in the next one. Bye!